These are appeals in the matter of Bath Racecourse Company Ltd and Starboard Hotels Ltd and Liberty Mutual Insurance Europe and others.
My Lords, I appear with Mr Walsh on behalf of the insurers, that is Liberty Mutual, Allianz and Aviva.
Yeah.
The remaining policyholder respondents are Starboard, who are insured by Liberty Mutual alone, and Bath Racecourse, who have the 3 years quota share insurers. Mr Gruder and Miss Higgs appear on behalf of Starboard, Mr Kramer and Mr Day appear on behalf of Bath Racecourse. There were additional policyholders. The court understands that there have been settlements in respect of a number of them, and the appeal withdrawn in respect of the causation issue on Gatwick, so Gatwick is not a party.
In relation to the furlough appeals next week, we still got Gatwick involved.
Yes, that's correct.
So there are three policy holders still in the frame, as it were.
Yes, for next week certainly. Yes.
Yeah.
Yes.
I'll get the gripe out of the way at the outset. The preparation of this case has been pretty shambolic, with respect, in the sense that the court has spent quite a lot of time trying to work out what on earth it was we were supposed to be reading, hence asking you for a reading list. What it was that was still in the frame, and a whole series of slightly complicated documents which involving, for example, redlining through a whole load of stuff in skeletons and so forth, when it would have been a lot easier if you'd simply produced a skeleton argument that had in it just the arguments that were necessary for the purposes of these appeals. We might have found it a bit easier. But we are where we are, and we've got nine authorities bundled, I think, which does seem to have destroyed a lot of trees, really. Anyway, there we are. That's the gripe. But for future reference, you might think about a bit more streamlined preparation.
Well, I apologise for that, my Lord. The redlining was an attempt to be helpful, and I'll take full responsibility for that, because that was, as it were, rather late in the day.
Thank you very much. I'm not going to complain again. So,
but just on the authorities, my Lord, there are, as it were, 3 sets, because there is
Can I just ask? I'm sorry, Mr. Scory. Can I just ask this? We've got a transcript. Have we, or a live no transcript or not?
We have a transcript.
It's not live now, but are we going to get the transcript
at the end of the day, my Lord? Yes.
The end of the day,
yes.
Because I did authorise something last week.
Yes.
Okay.
End of the
So
day.
as long as we're going to get that's for the purposes of note taking.
Yes. Just in terms of the authorities, my Lord, there is a set of common authorities which are relevant to both this appeal and that next week.
Yeah.
Set labelled insurers authorities, they're in fact the extra ones specific to today, and then the furlough, which are specific to next week.
Okay.
Now, in terms of my client's submissions today, I'm going to address the composite policy issue, which is with the issue of principle between the parties. That's ground number 3. There are 2 separate grounds, 4 and 5, which concern discrete issues on specific terms of the Bath Racecourse policy. And Mr Walsh is going to deal with that briefly at the end. Now, that composite policy is directed, that issue is directed to the 2 policies. A Starboard policy is at bundle what's been labelled SH.
Yeah, I took it out and put it.
And the judge below held the limits for the prevention of access non-damage clause of £1 million applied per occurrence, and in so doing the judge rejected the argument that was expressly in the aggregate. But on the composite basis, the judge also held that therefore applied per policyholder. As
It's
to
common ground. It's common ground. It's a composite policy.
Yes. As to the number of occurrences, that wasn't before the judge below or this court. That's yet to be determined between the parties at trial. The composite issue today is, are those limits per occurrence enjoyed individually by each policyholder separately by reason of the nature of the policy as a composite policy, or is that the limit per occurrence that applies across the board? So it's sort of like whether one looks at it at a macro level, this applies to all the interests thereby insured affected by this occurrence, or whether one looks at a macro level individually, that everybody affected by that occurrence has the 1 million limit. The second policy is a Bath Racecourse policy, and there the limit's £2.5 million. And the judge below held that that applied per loss.
Well, that's a different point. That's the point that Mr. Walsh will deal with, is it?
But whether it's per loss or not, Mr. Walsh is going to deal with. But there is then a further issue, which is even if it's per loss, is that, again, at the micro level, each individual policyholder is entitled to 2.5 per loss, query what per loss means? Or is it open to me at the trial in May, when this is being determined, to say that per loss can and should be construed as a loss at a macro level, such that there's a 2.5 million limit. So in respect of that issue, what I'm really asking this court is the ability to argue that come the trial in May, where the other side seek to preclude that by, as it were, having that determined against me. The issue, the court may think, well, that's only part of the issue.
The judge has decided, hasn't he, that the words any one loss are still in there.
Yes.
So it's 2.5 million any one loss.
Yes.
With a maximum indemnity period. And so the only question thereafter is, well, what's meant by any one loss? I mean, it's not an aggregate limit on that hypothesis. How can it?
No, but it still gives.
It's only one loss, but I mean, if you've got, as you have in arena racing, Bath Racecourse, forget how many insurers there are, 21 or something like that. There's quite a lot of them anyway.
22.
22. One would have thought that 2.5 million any one loss means what it says. So if all 22 of them have suffered a loss, they get 2.5 million each.
Well,
I mean, is that point really, assuming that this court were to find that Mr. Justice Jacobs got that point right, are you saying that there will be a further trial about whether any one loss actually means in the aggregate or what?
Well, that's been held against me below, because it's been held that it applies to any one loss, and because of the composite nature of the policy, in one paragraph, the learned judge held that therefore applies to everybody. He didn't grapple with what any one loss meant, because that wasn't before him.
No, he says in, which I forget which paragraph it is, but he says in 267 or something.
Yes.
Somewhere around there. He says that this particular point was not before the court on that occasion.
Yes. So the issue we're going to have in May on Bath Racecourse is not whether there is one loss suffered by each. That's part of the issue. And I want to say in May, for various reasons I shan't trouble the court with today, that one should read one loss to mean that loss is suffered at the macro level. But there have been recent amendments where the number of alleged losses per policyholder has increased exponentially, where there are currently over 1,500 alleged separate losses, each with their own limit of 2.5 million. And one of the points I'm going to come back to is, can one really say that this was meant
that's
to...
That's not for today. Appeal, no.
No, but as it were, all I'm asking this court to do is allow me to argue the issue in the round come May, rather than have it precluded now that the composite issue determines that one loss means that one is at that macro level rather than at the micro level rather than the macro level.
The issue for today is whether the limit is per each assured or per all assureds. Is it
Yes.
as simple as that?
Yes. Could I just make a preliminary comment about the law and approach to construction? This should not really be one of those, yet another case where one needs to delve into the approach to construction. You'll have seen from the party skeletons that there appears to be agreement as to how to go about it. But I do wish to stress one point. One is told to construe these policies by reference to the understanding of a reasonable policyholder. Such a policyholder is obviously more sophisticated than a consumer, than a homeowner buying home cover or car insurance. But they are not lawyers. One can and must dismiss the pedantic lawyer. But it may also follow that one cannot imbue the reasonable policyholder with any particular knowledge of insurance law, still less a detailed appreciation or understanding of the implications of a policy being composite, single, joint or otherwise. Now that's relevant to the issue of whether the policyholder would have any a priori expectation as to the number of limits or the basis of cover. Now,
Policyholders will have a broker.
Oh yes, I accept.
The broker will entirely understand what the difference is, and if the policyholder says, do I need a separate policy for each of the companies, or is it all right if it's in a single policy, the broker will advise him as to the effect of the law on composite policies. Isn't that part of the matrix?
Well, as your lordship said in Brian Leighton at paragraph 49, policyholders will be advised by brokers. It is their job to understand the policies, and if not, to seek advice. What your lordship there confined it to in that paragraph was the basic principles of insurance law and the meaning put on phrases used in policies by consistent judicial authority. Now, true it is that the broker in those circumstances may be taken to understand that a composite policy is ensuring the separate interests of the people being listed as a policyholder. One doesn't extend beyond that to imbue the broker with any expectation as to the extent or nature of the cover. As with a single policy, it all depends on what was agreed.
But the very straightforward point that's taken against you, as I understand it, is that if Starboard had followed the same line as Gatwick and each hotel had been the subject of a separate contract of insurance, there would have been a limit, a 1 million limit per insured under each of those policies. And merely by taking the, and it's a point the judge made as well, the commercial common sense approach of having a composite policy shouldn't deprive the insured of what would have been the position if each had had their own separate policy, unless the wording of the policy is very clear that the limit is an aggregate limit for all the insureds taken together.
That conclusion,
the insuring clause suggests that it isn't, with respect.
Well, I'll come on to the detail of the clause at the second part of my submissions. But just on that first point, namely that there's been some accidental omission, I don't accept that for a moment, because it all depends on what was agreed. And what the sub silentio, what the court is saying by making that point, is that if this had been done differently, the parties would have had different consequences. See Gatwick. Well, that involves construing this contract by reference to what different parties have done by way of a different arrangement. Because it may well have been that if they had, in this case, gone down the route of separate policies with separate limits.
No, it's not construing the composite policy by reference to some other policy, it's simply making a perfectly sensible commercial point that if they had proceeded in that way, that is what the effect would have been, and that must be something that the court's entitled to take into account.
Well, the missing element in the analysis, my lord, is this. That would be right if the premium were the same. But if the premium were to be different, then that's a different bargain. And that would have been reflected in the premium. Now, there's no evidence before the court as to what the premium would have been, namely whether it is rated more beneficially on a composite basis than a single basis. And the court may think, well, why would that be? Well, the only material I can point to is what was said in argument in the New Hampshire case, where that very point was made in argument by Mr. Rokerson. So it is conceivable and possible that if one were to have the interest insured individually, a la Gatwick, different premium is charged, in which case there's a different limit, but that's been paid for. The issue is if one is dealing with it on a composite basis and potentially obtaining cheaper cover, there may be different consequences for the extent of that cover. And without knowing the pricing or the rating, it takes the court no further.
Can I ask, the authorities tell us, in particular Lord Hodge in Wood and Capita, that it doesn't matter whether you start with the contextual analysis or start with the textual analysis. And surely here, the fact that these are composite policies is part of the context, which must be taken into account in the exercise of interpretation. So why do you start by saying that one shouldn't start from there, because you're perfectly entitled to start from there?
Well, I don't deny that one has to take into account that these are composite policies and therefore ensure the separate interests of the parties. One is looking to see then, given that common ground that this covers separate interests, one asks the question, how are they covered? In what way are they covered? And what is the extent of their coverage? Because it may not be the same across the board at all. And where I jib at the approach below is the adoption of the approach in Corbyn and King, where there was an expectation. And in my submission, that expectation is unprincipled and unjustified. That's the real complaint. All I say the court should do is not have any expectation that each policyholder enjoys the same. Each policyholder has interests which are insured on a composite basis. But what is the extent of that? One needs to look at the terms.
Well, we have to look at the context and the terms together. So it's absolutely clear cut, isn't it? On the authorities, you look at,
yes,
it's an iterative process where we look at both.
Yes, but I don't look at both, my lord, with an expectation that I'm going to look at them and find the answer I'm looking for, namely that there is the same limit and the same extent applied to both. It all depends on what is said in the policy.
Of course it is, but equally, again, there's lots of authority on this rainy sky. One looks at the context of business common sense. And if you have 24 hotels separately insured in separate policies, it would be commercially, a matter of business sense, strange if they had agreed an aggregate limit of £1 million.
Well, I see, that's where I do take issue, my lord. That is not strange. It depends what is said. If one looks at, I'm going to take you in a moment to the detail, but if one looks at the first list of the sums insured, one does not find individual limits per hotel, because this is not on a schedule basis. It is on a portfolio basis.
And we're looking at the words, aren't we?
Yes, but my point there is, exactly, one just needs to look at the words. If this were a schedule policy, where every individual interest was separately identified, one could see the argument would be stronger that what is being covered here is everybody's individual interests. But that's not the basis on which it's presented, and rarely is in a property context.
But that's the effect of your submission. I mean, okay, on the facts of this case, it is true, yes, on the facts of this case, is that each of the insured gets something in the region of £48,000.
My lord, if that's the arithmetic, that is the
Well,
arithmetic.
it's either, if we say there were 20 of them, it'd be 50,000, wouldn't it? So presumably the 22, I think it's 48,000.
Yes.
My maths may be right. Somebody correct me, but I mean that's the real point.
But if one has no,
And the point my lord's making to you is that that just doesn't make commercial common sense.
but that assumes, my lord, that there should be more. But what is given depends upon the terms, and the fact that it says 2.5 by way of an extension, which, as it were, an additional extra bolt onto the basic
Well, that's a
property
different
damage.
policy, isn't it? That's the other policy.
And yeah, well,
We're dealing here with POAND, prevention of access non-damage. Item 15 in the business interruption extension schedule.
my lord, yes, but still, my point is, it's an extension.
1 million.
I mean, just to grapple with the merits of that point, that limit divided, as your lordship's pointed out, per occurrence would be, say, 50,000 or thereabouts per policyholder per year. But of course, that assumes that every single policyholder has a claim in that year. Whereas if there just happens to be one incident because of one terrorist event or one burst gas pipe or whatever, then there's only one occurrence in the year, and that limit will be available for that single policyholder who suffered. What one can't do is construe this with hindsight by reference to what has transpired and posit that therefore everybody intended earlier that there will be coverage across the board.
Well, no, but the point is a slightly different one in respect, which is that if, taking that point, can it really have been intended that a claim by one of 22 insureds who supposedly have the same cover under the policy is effectively thwarted by the fact that somebody earlier in points of time has made a claim for the full million, or made a claim, for example, for 300,000, so that it goes down to 700,000. 3 claims ahead of the one for COVID, each for 300,000, and the hapless fourth insured only gets 100,000 when his real claim is $1 million.
My lord, yes, I say that's not surprising at all. One tests it with a basic.
So it's not surprising in the context of a policy which covers one insured and only one insured, and there's an aggregate limit, because unless there's the policy limits are reinstated in some way, I follow the point that that's not this case. This is a case where there are 22 insureds.
Lord, yes, well, let's just, one can.
So in my example, the fourth policyholder and any subsequent policyholders have insurance that's pretty worthless.
Well, my lord, no. The group has had, because although these are separate interests, they are related interests. So if one were to take a slightly different example of excess liability, one may have 22 parties, one could have 222. There will be a limit of, say, $100,000 or pounds per occurrence. Now, it may well be that there's a mass tort in the US for an operating company, and they largely exhaust and may well burn through that. If there's then a more modest but still serious claim brought in the High Court in this jurisdiction for a different problem, in the same policy year, the answer is the limit's been exhausted. There's no expectation ex ante that everybody gets the same limit. So if one looks then in the property context, i.e. here, just as one has the aggregate limit, it's clearly an aggregate for the overall buildings and for the general turnover, if there are then the extensions, as it were, the extra cover, there's no assumption that that extra cover is for everybody fully. It may seem to be a limit that if any eventuality happens that triggers that insured peril, then one can have cover but up to that limit.
And you say, well, it all depends on the premium. The premium in this case was £80,000 odd for the whole of the material property damage, which then had business interruption, business interruption added under section 2, and then further non-damage prevention of access, all for your 80,000.
Oh, yes.
So you say it wouldn't necessarily be surprising
No.
if it were $1 million for the whole policy.
Quite. So I've got two overarching submissions in support of the appeal. First, as I've just been outlining, I dispute that if one has a composite policy, one begins with any assumption or expectation that there are separate policies with separate limits provided to each.
Well, the first half is common ground. There are separate policies, essentially, or separate contracts.
Separate contracts.
Separate contracts, right.
That's important by macro point, because what I say is wrong as part of this first set of submissions is to treat these contracts as if they were in splendid isolation from each other. They are interrelated, which allows one then to have a limit which can apply across the board, which might be exhausted by party A and leave nothing to party B. That's exactly what happens in the expectation in the example I gave of excess liability. And the same will be true of D&O cover. And the second set of submissions is focused then on the terms of these two policies. And I say that if one looks at the terms, that indicates that they are on an aggregate basis across all policyholders, and that one doesn't multiply the stated limit by the number of policyholders who are thereby insured. What we say is wrong is that the composite nature of the policy requires one by default to presume it represents a bundle of separate policies with separate limits, as if written out for each policyholder, with the limit applying entirely to that individual. Likewise, we say that Bath Racecourse is wrong to suggest that one construes such contracts negatively, namely that there's some default rule that with composite policies, that there are multiple limits enjoyed individually and serially, unless there's wording to the contrary. Instead, we say that one simply approaches the contract like any other insurance contract. What is covered, on what basis? Yes, one may know that separate interests are covered by a composite policy. But that fact tells one nothing about the extent of the cover of those separate interests or the limits applicable to them. It all depends on what's been agreed. Now, in that regard, complaint is made by both respondents that we have erected a man of straw in respect of this composite issue, and that they have always sought to rely upon the precise terms of the policies rather than any presumption. Now, if that is meant to be a criticism of my appeal, that is unfair, because the way this case was put below and the case I had to meet was that the limits applied separately and individually to each insured under the composite policies because they were composite. Not necessarily because of the terms, but because of their composite nature. And one can see that if one has still open the Starboard bundle. At page tab 5 is the particulars of claim. If one goes to paragraph 9A, page 21, one sees there the limit of 1 million applied. And I go over the page. Sorry, my lord, this is headed. Right, there are the catchy title, case-specific cause / supplementary bundle for appeal on Starboard Hotels. It has a Starboard policy in it.
Which?
Tab 5 should be the particulars of claim for Starboard. And there should be a further thin file for...
particulars of claim. Right, where are we looking?
Page 21, my lord.
Yeah.
Paragraph 9 at the bottom. The limit applied, I turned over the page, so paragraph 1. Separately, in respect of each individual contract between each claimant and the defendant, as the said policy was a composite policy. So it was because it was composite, it was said to apply multiple times. And that is repeated at paragraph 43, so paragraph 1 at page 30 of this same tab, where the plea in paragraph 9 one sees there is repeated. And the court will have seen from the judgment below that that was then tracked and reflected in issue 13 of the preliminary issues, which was framed for Starboard, quote, as the said policy was composite. So that was the issue I had to address below. In respect of Bath Racecourse,
The paragraph 9.2 is a separate point which isn't dependent upon it being a composite policy as such, simply making the point that to the extent that each insured had the use of each hotel That's each individual insured hotel access to is prevented or hindered, etc. So that's simply picking up, isn't it, the fact that each insured is entitled to rely separately on the insured peril.
My lord, yes, I'm not saying there are other arguments. I'm just focusing upon the argument that was, that, as it were, picked out for the preliminary issue in 9A. And I'm just here countering the point that this doesn't matter. One can look at the wording of the policies. Well, with respect, it was advanced below as being important. It was identified as a preliminary issue, and that's what was dealt with. Now, the court may think that that was not a prudent way to dissect the issue of limits and construction, and it may have been death by 1,000 cuts, and the insurers may complain about
where
that.
is issue 13?
That is in the call bundle, my lord. It's recited in the judgment. At
Page 56, is it?
my lord, yes, in the terms of what you say with the page.
Sure where.
It's entitled, my lord, Joint Call Bundle.
Sorry, which?
Tab 1 is the judgment, page 57.
Which page?
57, my lord.
Yeah, well, 1 and 2 reflect paragraph 9, 1 and 2 of the pleading, don't they?
Yes, but and one sees it in terms of the answer, if one goes on to page 60, subparagraph 1, his answer is yes, namely as the policy was composite. And then there is, as it were, a combined answer given to 2 and 3.
Well, that's really because of 3, isn't it?
Yes.
Because 3 is the point about each of the insureds says it suffered a series of interferences.
Yes.
So obviously the court wasn't deciding that issue because that's a fact-specific issue it couldn't decide anyway.
Just not sure how the point this is, because there's no doubt that if there was just one contract of insurance, then it would apply to that one contract of insurance. So the point only arises because it is a composite policy, and I don't think anyone's saying that it arises without looking at the words. And so I think what's always being said here is, as this is a composite policy, should it be construed as being a series of limits or one aggregate limit?
Unless the wording makes it clear it's an aggregate limit for everybody.
I'm not sure that the court, where that issue has been articulated, is any different from the thrust of my submissions. And the court may think, well, why are we spending the time on this? There's obviously the import for this case because of how it has been framed against me and how it was advanced in the trim issues below. But if the court's concerned about the wider implications, then this goes beyond this case. And the court would appreciate that in light of what was said in Corbyn and King, the issue is being raised that there is an expectation where prior to Corbyn and King, that argument was simply not in the mix. And that is causing some disquiet.
When you look at you say that, there's no evidence about that at all. We've got no idea. I mean, that's like saying Well, when I saw that, I was irresistibly reminded of an occasion when Mr. Justice Lloyd said to Mr. Pollock in court, Mr. Pollock, well, I'm interested in your submissions on the law, not your submissions about what people argue with each other at tea at 4-6 Court.
That's right.
Sorry,
my
that's a
lord.
bit offensive. You follow the point. Look, it's the same point, really. I mean, there's no evidence as to what the market may or may not think of this, and actually, that's completely irrelevant.
In the context, my
That's a sort
lord.
of plea in terrorem, Mr. Scurry.
Well, and I, with respect, say it's not in terrorem. This is not individual litigation. These are test cases.
Well, we know that there's a whole pile of other cases which apparently have been stayed pending this one, or pending these appeals, and for whatever reason, some of them are settled and some of them haven't. So that much is obviously part of the overall sort of picture. But the court will decide what this all means, and if the market is upset by that, well, that's just tough.
Well, I understand that, my lord. All I'm asking is the issue be addressed, because there is a world of difference between an approach to the construction where one accepts it's composite and one has to construe the terms, as opposed to an argument between the parties whereby one side says, no, never mind what the word says.
Well,
there's
I
an
understand the
expectation.
point that you, I mean, I understand that you cavil at presumptions or expectations.
Yes.
I mean, that's obvious, isn't it? And you can legitimately say, well, that's not the right approach, because it all depends on the construction of the contract, and you shouldn't approach construction of the contract on a sort of basis that it must mean something, it must mean something in particular because it's composite.
Yes,
That's the point, isn't it?
there's my point.
Yeah.
If I can just spend slightly longer making that same point.
Yeah.
there's sort of,
Yeah.
if one takes the argument as articulated at Corbyn and King and followed by the judge below, it does follow the supposed logic of the nature of composite policies as proceeding on the basis that if there's a composite policy, there is a bundle of separate and distinct, possibly independent contracts of employment, and then one contract of insurance, and then one then treats that as if those separate contracts were written out individually for each policyholder, with all the terms and the limits, which are therefore enjoyed individually, or at least that is the expectation. And we say that that is wrong, that Corbyn and King took that point too far. Now, first, I do not dispute that a composite policy obviously provides separate and potentially independent coverage for the separate and distinct interests of each insured, but it does so in a single policy. Now, it's the distinct nature of those interests which distinguish a composite policy from a joint policy. I'm not going to take the court to Arnold to make good that point, but with the composite policy, one's dealing with co-insurance of distinct interests. But in that context, one has a policy which is reduced to writing, consistent with Section 22 of the Marine Insurance Act. And just as if one had multiple insurers subscribing on a credit share basis to that policy, one may have separate contracts, but there is but one policy. Again, that's Section 24 of the Marine Insurance Act. But what one cannot do and should not do is start from any presumption that one's dealing with separate policies. There is but one policy, the overarching umbrella document, the framework agreement, that applies to all the interests and all the parties. And that single policy, therefore, has the ability to affect the bargain struck in respect of the individual interests insured on a composite basis or multilaterally. And therefore, one can either consider a composite policy to be a bundle of individual bilateral contracts contained within the same policy, alternative of reaching the same conclusion, one could analyse it as a multilateral contract with multiple parties, where the separate interests are insured on the terms set out therein. But what matters is that they're not wholly independent. They all form part of that composite policy. Now, related to that, if there is one policy, which there must be in my submission, if one deems there to be individual contracts of insurance, those are not treated as if they were freestanding, independent and hermetically sealed from each other, as if written out separately for each policyholder in respect of their separate interests. Therefore, the fact that one has a policy with a limit of X pounds does not mean one treats that as a bundle of individual contracts written out with the name of each individual policyholder with a limit of X. A similar argument, albeit not in respect of limits, but on terms more generally, was advanced in the Technip case. And this is in the insurers' authorities for today, volume 2, tab 19. Now, just to explain the background here, Technip brought a claim for an indemnity due to damage it had caused to a wellhead platform owned by KJO. There was a composite policy with a familiar exclusion for owned property, namely owned property of the principal insureds. And KJO, the owner of the platform, was a composite policyholder under that policy. So both Technip, who had caused the damage, and KJO, who suffered the damage, were policyholders on a composite basis. And the insurers said that looking at that policy as a whole, the exclusion for owned property owned by the principal insureds included KJO, and therefore there's no cover. And Technip, the claimant, said it had no interest or ownership interest in the platform because there were separate policies of insurance for Technip and KJO, because one should treat the composite policies as individual. One looks at principal insured on Technip's contract, and that's Technip. One looks at principal insured on KJO's, that's KJO, and therefore there was nothing on which the exclusion could bite. And that was rejected by Mr. Justice Jacobs at first instance. One sees that, tab 19 at page 742. At paragraphs 159 and in particular 160. If I could ask the court to read those paragraphs, please.
And that's just a decision, isn't it, that even though it's a composite policy, if one focuses on the as it were, the separate contract between KJO and Megagulf. KJO was a principal insured within the meaning of the policy.
Yes.
That's all it's deciding.
Well,
It's a matter of construction. Principal insured means not just Technip, but for these purposes, KJO as well.
yeah, because but part and parcel of that conclusion is the analysis that it may be a composite policy, but one doesn't then read the individual contracts as specific to that individual interest of the policyholder. One looks at the individual contract of insurance, and that includes with it, as it were, all the terms at the macro level of the composite policy. So if one has it here, one has a definition of principal insured, and that applies across the board for everybody's interest. And it's a small step from there to
Where
say,
was the
well,
definition?
sorry. Seven, 705, sorry.
So that's that covered KJO because they were joint venturers.
Yes. This was also addressed by the Master of the Rolls on appeal, which is at tab 25. At page 896, paragraph 34.
Should we read those?
Please, my lord.
Yeah. Nothing surprising in that.
But I rely upon that in support of the proposition. If one then looks at the macro level, at the composite policy level, and finds a specific type of loss or damage covered, and there being a limit for that specific type of loss or damage, then when one is then looking at the individual rights of the policyholder who may have suffered that type of loss, one does not assume that that limit is peculiar and specific to that policyholder. It may well be just the generic loss which is insured across the board, because if there's one limit being given in the policy for a particular type of loss, that is the limit for that loss, no matter who suffers the loss.
Well, we'll obviously come to the particular wording in these
Yes.
policies, but it might be said that if you have no more in the wording than the insuring clause, which says this is the liability, and a limit which says this is the limit of liability, because the insuring clause is a clause which, properly interpreted, means this is a liability to each assured. That colours the expression limit of liability, because the liability you're talking about is a liability to each assured, and that therefore raises perhaps a presumption, or at least an expectation, that the limit of liability is to be treated in the same way as the liability itself.
I'll come on to the detail in a moment of each policy, but in my submission, one couldn't start from that basis if one has, as here, a property cover which is not on a scheduled basis. It's on a composite basis, which is providing insurance by reference to the limits on a cumulative basis. Because if one takes your lordship's assumption, it would mean that if I had 10 factories, each worth 10 million, and therefore the cumulative total insured is 10 million, then looked at through that expectation, each policyholder would have a 100 million limit. But that's not the expectation. The expectation is...
I'm not sure that is the logical consequence of what I'm saying. I'm saying if the liability, the insuring clause, is to be interpreted as meaning a liability to each insured,
Yes.
not each property, each insured, then if, and this is all subject to what the actual wording says, but if you have nothing more than an expression limit of liability, one asks limit of what liability? And if liability is defined in terms of liability to each insured, that might raise the expectation that the limit is a limit of liability, brackets, to each insured. That's the point I'm putting to you, not a per premises.
No, but that's a slight danger dealing with in the abstract, because if one has a policy where there is a limit of indemnity, I'm slightly keen to avoid limit of liability because there can be one of the criticisms made of this policy was that certain of the nomenclatures are appropriate for third-party liability policies as opposed to first-party property policies. If one has a limit of indemnity which sets out the extent of the insurer's obligations, and one says, well, is that to each and every individually? But one needs to look, well, what is the limit?
I totally understand. We've got to look at the particular wording. All I'm putting to you is that if one has nothing more than an insuring clause which says we agree to indemnify, leave aside liability if you'd rather, we agree to indemnify in relation to this, and then it simply says limit of indemnity. If the clause which says we agree to indemnify means, because it's a composite policy, we agree to indemnify each of you, then that might raise the presumption that if one has nothing else than just the word limit of it, or limit of indemnity, that's a limit on the amount of the indemnity agreement, i.e. the amount by which we agree to indemnify each insured. That's the point I'm putting to. I'm not for a moment suggesting that you don't look at all the wording and it may be much more complicated on this wording and so on. But is that a way of as a matter of construction, of explaining why, if you've got nothing else in the wording, you may start with a presumption that the limit of indemnity is to apply to each assured if the indemnity itself is to each assured?
My lord, no, I don't accept that. For two reasons. One always has something else, the terms, but most specifically, when one sees a limit of indemnity is X, if that limit of indemnity is in fact a cumulative total of all the interests, one wouldn't assume for one moment that therefore that is the limit applicable to each. On the contrary, one would say the limit of indemnity available under this composite policy at the macro level is the most this insurer will pay in respect of the disparate interests insured hereunder.
So you say, if anything, there's a presumption the other way, but that limit of indemnity means aggregate of all indemnities rather than...
Well, certainly, and I'll show you...
the limit of each individually.
I'll show you in a moment. On a non-scheduled property policy, when one sees the word limit of indemnity, and it's not said to be in the aggregate, but there's no debate between the parties, it is in the aggregate, because it's obvious from the amounts involved that was on a cumulative and therefore aggregate basis, and it could not be argued credibly that each policyholder could in principle obtain the full amount of the limit. If there were a raging tornado which destroyed all the hotels, each wouldn't receive a limit to the full amount. Now, I quite accept that we're not here on a value property basis, but it's not inconceivable. Some of the examples I'm going to come on to later. If one has two factories, they may both be valued at 10 million each, and therefore the limit of indemnity under policy is 20 million, the cumulative amount for the first party property cover. Now that would mean that that is the overall aggregate limit for both those parties' disparate interests. And one would assume that if there were a raging tornado and they were both knocked down, that there would be 10 million each to rebuild. But it's not inconceivable that when that tornado goes through, due to changes in health and safety regulations, it costs a lot more to rebuild because there needs to be greater hygiene requirements or new aircon systems, etc. And therefore it could cost 15 million to rebuild the property. It can't be said that each policyholder can claim 20 million limit each and therefore recover their full 15. The 20 million on the page obviously covers their combined interests, and they would understand that to be the case.
But that's a different, in the case of this policy, that point doesn't really work. It doesn't work in that way, because true it is that if you go to, now looking at the material damage section in the schedule, it is absolutely right that if we just focus on buildings, page 54 of the Starboard policy, limit of indemnity 166 million. But if you then go to the material damage cover insuring clause, page 76, this section shall cover, in accordance with the indemnity agreement, damage to any of the property insured for which a limit of indemnity is stated in the schedule. The company will pay to the insured, the individual insured, the values of such property at the time of the damage, or the amount of the damage, or the company's option, reinstate or replace. So that in relation to material damage, it's fairly obvious that the limit of indemnity is an aggregate limit for everybody.
Yes.
Total value of all the properties put together, but the individual insured can only recover the value of its own property.
Yes.
Which I don't think is separately, well, it may be separately stated anywhere, I haven't seen that. But in relation to business interruption, the position is different, or at least potentially different.
I mean, the point I was seeking to address from my Lord Justice Popplewell is, as I understood it, the point whereby if one were to look at page 54 by way of example,
yeah,
and the policyholder sees item 1 buildings 166 odd million, and one sees, and one were to read elsewhere and say, well, that's the limit for buildings, and that's the limit of the insurer's liability to the policyholder, that would be the limit for the individual policyholder.
no, because the reason for that is the one I've just put to you, which is that the declared value is 144 million, limit of indemnity 166 million. You then go to clause 1 of the material damage section, where it makes it clear that each individual insured can only recover a maximum of the insured value of its own premises, which are declared value. Somewhere in this policy is presumably a series of declared values, or whether it was on a...
There would, no, not as part of the policy. It's not a scheduled policy.
Well, it must have been somewhere.
But they were maybe provided as part of the...
So if somebody's hotel burnt down, there must have been declared value for that hotel that would then give rise to a claim under the material damage section. But the owners of the Ibis Hotel in Leicester were not, whose hotel burns down in a fire, and it has an insured value, let's say for the sake of argument, of £10 million. will not look at this policy and say to themselves, aha, we can recover 166 million in respect to our hotel in Leicester.
No,
This is
but
nonsensical.
in my submission, the reasonable policyholder, looking at this diligently, even before turning to page 76, that would strike him or her as obvious just from reading page 54. Because that's on a cumulative basis. And the policyholder knows that, because the risk manager presenting this knows the group's interests. And therefore, there's no reference there to in the aggregate, but it's as plain as a pikestaff. Anybody reading that within the policyholder, that is in the aggregate. There's no expectation at all that that is a limit per policyholder.
Well, that's because it refers to buildings plural and to declared values plural.
Yes, but if one goes over that, goes onto page 56, my lord, which is business interruption. One has
So which page are we?
56, my lord.
Yeah.
One has gross revenue singular. But again, that's on a cumulative basis. Nobody's suggesting, it couldn't be suggested credibly, that 89 odd million of the limit is not the aggregate limit for the group's interest. It doesn't say so in terms on that page, but it's, in my submission, clear and will be understood as such by the reasonable policyholder.
Yeah, but it doesn't follow from that the extensions, when the figures are given in the extensions, they would be interpreted in the same way as being a total the basic, what might describe the basic cover, which is items 1 to 9. The end of that in bold, total business interruption 106 million, the declared values are 79 million. Perfectly obvious that's the total.
Yes.
For everybody.
Yes.
Then it goes on to have a series of extensions, and the series of extensions are complete silent as to whether they're in the aggregate or per policy. And that's what this debate is about.
Yes, but again, if one's starting there, in just in terms of, I'm dealing here with what's said against me, there being an expectation that those would apply serially, one asks, well, why? Because the point I've just made, my lord, on the top half of the page would apply with equal force, even if it didn't say in bold, total business interruption. Because what's being set out there are limits which apply at a, as it were, the composite macro level across the board. And if that is right for certain items, then it's equally possible for that to apply to other items. And whether that's right or wrong depends upon the terms given. There's no expectation at that composite level that one replicates these limits per individual policyholder. That's my point. Now, just picking up on that to deal with the approach taken by the judge below. He dealt very briefly with it because he followed the approach of Mrs. Justice Cockrell in Corbyn and King, and therefore I need to turn to that case if I may. Now that is in the authorities, Insurers Authorities Bundle 1 at tab 13.
Yeah.
And if one turns within the judgment to page 449, one sees at paragraph 228, there are two strands to the argument, one construction, one based upon its nature as a composite policy. The judge held that logically the legal argument comes first, and that gave rise to the expectation of the prism through which she viewed the issue. but just dealing with paragraph 230, as to this, i.e. the composite issue, there is no invariable rule. Now, that we say is right. There is no invariable rule. One might think, therefore, that this does not assist with the issue of construction, and if there's no invariable rule, there wouldn't be any a priori assumptions or expectation. Indeed, in similar vein, if one goes on to page 450, paragraph 236 of the judgment, there the learned judge says it's fair to say that the conclusion may well turn on the facts of the particular case. Again, we agree. But if one goes back to 230 on page 449, just after having stated there's no invariable rule, the learned judge says it's probably fair to say that the expectation raised by the authorities is that a composite policy is treated as a series of contracts and hence will be treated as giving the relevant cover per contract. Now, in my submission, that's wrong. The cover being given per contract will depend upon what cover is being afforded by the composite policy. Ditto the limits for that cover. Because one may have a policy, a composite policy, such as a classic D&O policy, which has multiple policyholders, which, unlike here, have very disparate interests because of side A, B and C. And the policyholders under side A are very different from those under side C. And what they are given will all depend upon the terms of the composite policy at the composite level. If one goes back to Corbyn and King, it goes on to page 451. There's the uncontroversial conclusion that this is a composite policy. But then at 238 is where, in my submission, there is an error adopted by the judge below. Because the learned judge says, although it's not beyond the bounds of possibility, there could be a composite policy with a single limit which applies to all the premises and all the claims, that would certainly not be the expectation in the context of a composite policy. Now, that's framed in rather trenchant terms. It's certainly much stronger than the rather tentative approach adopted just earlier at paragraph 230 of the same judgment. But looking at the conclusion at 238, one asks rhetorically, why would it be that expectation? And to phrase it, it's not beyond the bounds of possibility, gives rise to the idea that it would be difficult and no doubt odd for there to be individual limits on a composite basis. But that, in my submission, is unjustified. It all depends on what was agreed. It's clear from Corbyn and King itself, as here, that the property damage cover and the classic business interruption cover were all on an aggregate and therefore cumulative basis. That's clear from paragraphs 11 to 13. That's based upon revenues of the group, and therefore the limit was in the aggregate. So in my submission, that approach there is wrong. I've already given the example to give the lie to this assumption of an excess liability policy, where one has multiple policyholders, not just the named insured, but all subsidiaries and all companies who have a shared balance sheet. If one starts an expectation in 238, then the assumption would be that each of those composite policyholders has a $100 million limit each. And with respect, that's not the assumption at all in the market. It's not what a reasonable policyholder would think, looking at the policy. That would transform a composite policy with a notional limit of 100 million into one which potentially offered coverage of tens of billions. Now, Starboard in its skeleton, paragraph 69, just for the court's note, that's in the core, tab 5, page 242, refers to what is said to be the well-known formula to limit cover in such a situation to 100 million per occurrence. Now, although not attributed, the language that's set out in that paragraph is taken from Article 2 of the classic Bermuda form coverage. And that may do what it says, but with respect, even absent that language, my point is there wouldn't be any expectation that each and every group company has a $100 million limit. That would not be part of the expectation of the policyholder. We've given in writing the example of a conventional hull and machine policy, which is on a composite basis with disparate interests, but there's no expectation at all that they have the full limits, simply as to their interests.
But the 100 million limit is plainly derived from adding together the total value of the, in that case, profit revenue of all the insured companies. So that's a fairly easy exercise in construction, isn't it?
Oh, yes, but the point I was making about the 100
And
million...
that was a point that was common ground in Corbyn and King anyway. See paragraph
Yes.
12. That the 98 million sum insured for business interruption was aggregate figures applicable to the claimant's premises collectively.
Yes, and the same in this case.
The judge then goes on to deal with the denial of access non-damage cover, which says their liability for any one claim will not exceed the limit shown in your schedule. So, on the face of it, which was, I think, 250,000, wasn't it?
Yes.
I mean, in Corbyn and King, it seems to me the answer was pretty clear, really, in the light of the wording of the DOAND cover.
But the way that worked, my lord, is very simply because one looks to the composite policy at that policy level, and one looks to see what the limits are, and it's clear either expressly or by implication that what is stated there is the cumulative aggregate total, and therefore the limit applicable to all. That's not difficult. Whereas if one looks at paragraph 238 of the judgment of Mr. Justice Cockrell, the inference by the words "not beyond the bounds of possibility" give the impression, in my submission wrongly, that it's quite a difficult thing to do. Not at all difficult.
But doesn't the presumption arise because when a party takes out insurance, they expect that the insurance will respond to a particular insured loss, and on your argument, these particular insureds will not have any insurance for the insured loss because not of anything in relation to them, but because other insureds have made claims. And the presumption is simply that unless it is clear that was what was intended, insurance won't be negated by virtue of what some other insurers claim. That's all that is being said, isn't it?
In my submission, that's not the assumption, because if there is a pot of money which is the limit of the cover, if other ex-hypothesized related parties have dipped their hands into the pot because of their losses, it just diminishes the pot.
Well, one can quite see that in relation to the pot of 106 million referred to on page 56, because you can see it's a pot, you can see how it's arrived at, and you can see that with each insured will be able to claim within that pot the current value of their property. But the extensions at the bottom of page 56, there's no such context for that to arrive at.
No, but the context there, my lord, is looking at it one sees the limit of indemnity, and one understands, as held by the judge below, that limit means limit means limit. So the limit of indemnity in the top half of the page has the same meaning of limit at the bottom half of the page.
So you say a limit of indemnity is in fact a defined term,
Yes.
isn't it?
Yes.
Limit isn't.
No, but the judge held below that that's to be, as it were, read across, so that there's no different meaning given to limit as opposed to limit of indemnity, and that's not been appealed. So when one looks at this page, one looks at limit, and one must read that as meaning limit of indemnity. So one has both limits, top and bottom, and I understand as a reasonable policyholder that my limit at the top is on an aggregate basis for the group, but not at the bottom. I say that's not the proper approach that the reasonable policyholder would take, certainly not in terms of any expectation. The reasonable policyholder would say, consistent with the idea that limit means limit, I know what my limit is at the top for the group, and I see I've got some extensions. So what does the group obtain for those extensions? One sees the figures set out.
Well, we've got to come back to the language and look at the insuring clause.
We do, but this part of my argument, I'm jibbing with the idea there's an expectation. Because in terms of the pot, to take an example of proper third-party liability, in my submission, there is no expectation that if one takes out that cover for, say, 100 million excess or whatever amount, that is to be enjoyed individually and serially by each and every group company. One would assume that if there is that limit and there is a claim against one policyholder in the US, then the pot is reduced to be available if there's any claim in the UK. Could I deal, it's relied upon in Corbyn and King, with New Hampshire,
Yeah.
which is in the authorities, same authorities bundle, at tab 6. Now this case concerns fidelity policies issued to companies within the Maxwell Group, and claims made by pension trustees and others for losses caused by the dishonesty of Robert Maxwell. One sees the policies in question at 133 between the hole punch and the heading background. Now, one of the many issues in this case concerned what the limits of liability were. Now, the limit of liability was £1 million, any one loss. And one can see that most clearly from page 168 of this bundle, where the Court of Appeal, it's not in the judgment of Mr. Justice Potter, but the Court of Appeal cites at the bottom third of the page an extract from the policy, the table of limits and liability, where one sees insuring agreement 1, employee dishonesty coverage form A, 1 million, there's an asterisk, and then at the bottom of the page, any one loss. Now, Lord Justice Staunton dealt with the issue L, the issue of limits, rather pithily. And one sees that at page 169, right, left-hand column, in the first sentence.
Yeah.
Now, that is a very pithy statement without much reason or explanation. That is a bedrock of the idea that composite policies are separate contracts of insurance with their own individual limits, quote unquote, in general. That's not a reason with respect or explained basis for why that would be the case in general. It also begs the question of how one could ever have a finite limit across all insureds if one is looking at the micro level rather than macro level, at the individual contracts of insurance with each policyholder. That conclusion must, in my submission, be read in light of the observation earlier in the judgment, page 168 of the bundle, prior page, right-hand column, under the heading Issue L, where Lord Justice Stawson said that this last issue is particularly difficult, largely owing to the obscurity of the contract wording. Despite the assistance of counsel, we found difficulty understanding the questions, let alone deciding them. Now, one sees it. One.
Look, Miss Justice Potter didn't have much difficulty deciding that point.
No, I'm going to come on to
Page
that.
155.
Yes.
Where he says, the answer to question 1 seems to me straightforward, given that I hold the insurance is composite. The effect is to create a separate contract of insurance, each insured under which the policy limits apply separately to each company insured. Subject to the proviso about what you do where the employees committed a number of fraudulent acts which affect more than one company, which was the issue they were grappling, or an issue they were grappling with, isn't it?
Yeah, but what, if just focusing on page 155, my lord, one could pick it up on the left-hand column, where there, Mr. Justice Potter, third full paragraph, the terms of the primary policy relevant to limits were as follows. And then he sets out insuring agreement 1, and one might be forgiven for thinking, given the third line, that that was meant to be an aggregate limit, because it uses the term in the aggregate. But again, by reference to the language of the policy, the next paragraph quotes the table of limits liability, which consists of the standard printed format, etc., referring to any one loss, which is what I showed the court a moment ago at page 168. Now, one did not need to get into a debate as to whether this was any one loss in the aggregate, because of what was then quoted next, just by the second hole punch under limits of liability. Section, I'm not sure if that's 2 or 11, payment of loss under insuring agreement 1 shall not reduce the company's liability for other losses under the applicable insuring agreement whenever sustained. So payment of one loss would not reduce liability for other losses. So that's reinforced by the any one loss cover, which therefore undermines any aggregate limit identified in insuring clause 1 across the board. However, it could have been an aggregate limit per loss if, properly construed, the policyholder's distinct claims constituted and or arose from the same loss. Put another way, if one looks on page 155, without the language under the heading limit of liability, the language in the insurance clause would have been a firm foundation to say this was an aggregate limit. So when one has on page 155 right-hand column at the bottom, which my lord, the Chancellor referred to a moment ago, that conclusion of Mr. Justice Potter is not one that is derived from its composite nature, it's derived from the wording of the policy. It follows from the terms that there's any one loss, and loss to one policyholder does not diminish any one loss to another, because that is what the term said, not by virtue of any expectation. And then one sees on 156 over the page, one looks at the 3 paragraphs between the hole punches there. There is a further limit for any one employee. So there is an aggregate limit if all the losses flow from the defalcations of the same employee. Again, it all depends on what's been agreed as opposed to any a priori assumption. So I simply say that in this case, the conclusion may well have been right on the wording agreed, but doesn't give rise to any foundation which would justify the assertion that there is an expectation of multiple limits simply by dint of the fact that the policy is composite. On the contrary, the only detailed analysis we have focus upon the policy language. Now, I should just deal with the point raised against me on this, that the ratio is clear, see Lord Justice Staunton, and it's binding on this court, and that I can't say that that's wrong, and there we are. That's the Bath skeleton at paragraph 25. I've already made points about the very pithy conclusion of Lord Justice Staunton at page 169. But the point, as I understand it, relied upon by my learned friends, is that New Hampshire is deciding that there are individual policies that constitute the bundle of contracts, each and every one separate and individual with their own separate limits. And to be fair to the Court of Appeal, they didn't actually decide that point. That was left to one side. It wasn't part of the ratio. And one can see that at page 163. And if the court looks at issue G, bottom right hand corner, and if one reads what follows and over the page, one sees there the Court of Appeal actually didn't grapple with the issue of whether there were separate or contracts wholly independent, because they relied upon Samuel and Dumas, which is quoted by them at page 162. So,
Sorry, what are you saying they didn't decide?
one sees that bottom of 163, my lord, technically one ought to inquire whether for each layer in each year there was one contract or as many contracts as there were companies insured, and if the former, can a contract be avoided for non-disclosure as against one or some of the insured but not against others. We feel that we are relieved from the need to answer those questions by the authority of the House of Lords and the passage already quoted in Samuel and Dumas. So as it were, the issue which we're all proceeding on the assumption that, without getting into the juridical basis, the composite policy, one multilateral document, or is it a bundle of individual policies, actually wasn't grappled with in terms by the Court of Appeal, because they didn't have to. And indeed, to be fair to Mrs. Justice Cockrell, in Corbyn and King, she did not place much reliance upon this case in support of what she thought was the expectation, and that's clear from paragraph 235 of heard a judgment at page 450.
So, sorry, I'm still not following what you're saying the Court of Appeal didn't grapple with. Is you saying they didn't grapple with the issue whether or not a composite policy is a series of separate contracts of insurance?
Yes.
Well, they did say at the end of F, page 163, we agree with the judge that all contracts of insurance were composite in nature, there being more than one insured and each being insured separately.
Yes, but that doesn't explain the juridical nature of whether one's dealing with one policy to which there are multiple parties, all subject to that one limit, or at the other extreme, whether one is dealing with actually not a general policy, but individual contracts that one should read separately and individually, or somewhere in between the two. So that point was not addressed. Yep, part of the premise in Corbyn and King that there's an expectation is the idea that, and it's the point raised by the court against me this morning, that one has one policy, it says a limit, why is there not an expectation that applies to the individual person's interest? And my retort to that is, well, that may have force if one is looking at it at a micro level, as in individual contracts, which are treated as written out separately. The Court of Appeal in Technique said, no, that's not how it's done. One is dealing with the policy as a whole, albeit by reference to the individual policyholder's insured interest, which includes the limits as stated. And if those limits are for the pot available, and that pot has been diminished by other interests that have depleted it, then it's been depleted. The same way any other limit's been depleted.
That's not what Lord Justice Staunton is saying at the top of page 63, is it? Once you've decided that each company was separately insured, the answer must be that in general there was a separate limit for each company.
Yes.
That's the process of reasoning. You can say, well, it's qualified by in general. You can say, I can understand you saying, once he's referred to Mr. Rokas' concession, that in certain circumstances you've got separate limits. That's sold the pass on the whole thing, and therefore he didn't need that general reasoning. But that is the general reasoning, isn't it?
Well,
at the top of 63.
Well, I do criticise the extent and basis of the reasoning, in the sense that one asks, well, why should one assume that?
I understand you criticise it. I thought at the moment you were seeking to say that wasn't really part of the reasoning, because when they were dealing with issue G, Lord Justice Staunton had declined to say in terms that they were separate contracts on every layer for every year.
Well, there appears to be a slight...
I don't think that's a qualification which really qualifies the opening words of the top of 63, does it?
Well, if one of the justifications raised for the top of page 63 is because of the separate nature of those policies, then that issue was ducked by the Court of Appeal, and therefore that, as it were, is a foundation which is unarticulated. If there's
what else could it be when he refers to each company being separately insured?
Because each company could be separately insured under a single policy, where the separate interests are insured under the one policy on a multilateral basis, as opposed to separate contracts of insurance. That issue wasn't addressed by the Court of Appeal. Well, it's obviously relevant if one's looking at a multilateral contract, and I say one always is with the composite policy, and one says, in respect to the disparate interests, as an insurer, what are my obligations to the risks presented? Here are my limits, and they apply across the board unless stated otherwise.
Well, I don't personally read any of the cases on composite insurance as ones where the decision that each insured is separately insured, and the limit of liability is a separate limit for each insured, as turning on an analysis that regards each of those separate insurances as being a separate contract of insurance as opposed to separate insurances of each individual insured under one composite contract, because the reality is there is only one contract as such. It's a separate interests are insured separately. And that was the point that was made by Sir Wilfrid Green in General Accident, which is picked up by Lord Justice Staunton earlier in his judgment.
Yes.
And the same point in Corbyn and King. It doesn't turn on there being separate contracts of insurance as such. There's only one contract of insurance in reality.
There's certainly one policy. It's said against
There's only
me.
one policy.
There are
But
multiple.
there are separate insurances under the policy.
Yes.
But this is semantics with respect.
Well, it has import, it's said against me. It has import because if there are separate insurance contracts and they are on terms of the composite policy, there are separate limits where I agree with your lordship. If there is one policy and that is insuring all the interests and one looks to those terms, what are the limits? Those are the limits that apply across the board unless otherwise stated. Because that's what a policy would do according to its terms. So could I then turn to the terms in question?
Yeah.
The Starboard policy, which in the SH bundle, tab 7. One sees at 52, the insured is Starboard and the associated companies. And one sees just below that, the premium is split out in terms of different types of cover, namely property, terrorism, employer liability. It's not split out per insured interest.
But so we start from obviously that insured is a plural noun, not a singular noun. Yes.
Yes. Because that is defined to include everybody. And then on page 53, one sees the 24 locations owned by the 20 claimants, although locations numbers 21 to 24 were not, as far as we're aware, hotels themselves, but rather offices or back office support. Now, this composite policy provides different types of cover. One sees that from page 67. So one sees there are different sections. That's 1 through to 9, although we're parties are principally concerned with sections 1 and 2. And then what one has at 69 are the definitions applicable to all sections. And these definitions are directed to the cover provided on a composite basis by this policy.
Just before, I'm anxious myself just to identify what the relevant insuring clause is for our cover. I think the first insuring clause we get of any kind is at 68 under indemnity agreement, which appears to apply to all sections, but is in the rather odd form. It's an agreement subject to limits of indemnity, capital letters as defined.
Yes.
To indemnify against all sums the insured shall become legally liable to pay. So it looks as though it's an insuring clause which actually is only relevant to section 7 to 9.
Yes.
Not. But we can leave that on one side. That's
Yes.
not the insuring clause we're concerned with for this loss.
For material damage, section 1, that's at page 76. But then for section 2, business interruption.
Which, cutting to the chase, it's page 140, isn't it?
We just
POAND
Yes, but as an extension under.
extension of page 81, which
Yes.
is the insuring clause for business interruption. I mean, it's
but 81 is not the insuring clause, is it, that we're concerned with?
no, it's supposed to be
Because 81 is only insures where there has been damage, and as a result, the business carried on is interrupted. So that is only the insuring clause damage business interruption, not non-damage business interruption. Is that right?
Well, partly. In the sense that your lordship's right that that posits the idea there's been classic property damage and
That's what it says.
so it's probably quite.
So if you wanted as the assured to say, here is where you have promised to indemnify me in relation to non-damage business interruption, the answer would be no, we haven't. This is only referring to damage.
Not least because damage is defined as direct physical loss, destruction or damage.
Yes, but if one looks at this, one sees there are two provisos, as made clear. There needs to be the damage,
Yes.
and then there are the limits.
Yes.
And that all makes sense for the paradigm example. And then has the extensions in this printed form. Before we get to the endorsement, so one goes to page 83, and one has the extensions applicable, which may or may not involve property damage. But one sees it on page 84, infectious diseases, and what at the bottom, in my submission, is important, is the emboldened text. Proviso 1 in the insuring clause of section 2 shall not apply to above extensions, i.e. there doesn't need to be property damage. But otherwise, that insuring clause is applicable to these extensions, if only in respect of the limit in proviso 2, which does apply to the extensions.
Sorry, proviso 1 is there has to be insurance, isn't it?
At the time of the damage, there shall be in force an insurance covering the premises against such damage.
So for infectious diseases cover, you don't have to have.
No.
Sorry, how does that help you?
So, but proviso, that's disapplied, but not 2. There's still the limit there. So one has the extension,
So that's for infectious diseases.
and then what one has then...
The claim isn't under that section.
Sorry, my lord.
The claim in this case isn't under
No,
that section.
but my point is that that is dealing with all extensions to section 2.
Sorry.
Page 81 is basic section 2, which requires damage. One then has extensions to that in page 83.
You have two extensions. One is for loss following damage to
Yes.
property and non-harm excluded, and the other is infectious diseases.
Yes.
And proviso 1 doesn't apply to the above extensions. So either of those two.
Yes. But
Right.
that means that for those extensions in this is the pro forma language of the policy, that one doesn't need to have the property damage, but the limit still applies. So one has the extension
For those two extensions.
for those two extensions. If one has other extensions as part of the extensions are extending what? They're extending the coverage under section 2. It's in my submission. It's in the name. It's extending the cover. One doesn't need the property damage that one otherwise would under section 2. Hence the extension.
That's what's said in relation to infectious diseases.
Yes.
The claim in this case isn't for infectious diseases loss. So we've got to look at where the cover is and where the agreement to insure is. And as my lord says, isn't that solely to be found at page 140? That's where the agreement to indemnify in relation to the loss in this case is to be found.
Yeah, as, with respect, part of the extensions to section 2.
It doesn't say, it
No,
doesn't,
it
it
doesn't
doesn't
say
say
that.
it's an extension to section 2.
No, my lord, no, but if one goes back to 67, one sees the schema of the policy. One needs to have an element of realism. There are different types of cover. And we're dealing with business interruption. And I've got a little extension to get my BI where there's no damage. It's part of the section 2 cover. It's not part of section 19 or 4, sorry, section 3
I
or
don't
4.
have any difficulty in saying it's part of business interruption cover.
But the fact is,
the wording, which I'm sorry to press you on this, but it is at the heart of your case.
Yes.
And what we need to focus on is the relevant contractual
Yes.
wording. And as it seems to me at the moment, of course you must tell me why I'm wrong. The important relevant wording is one at page 56. You've got a limit column, which at over the page at 15 has the 1 million. And at page 140, we have the agreement to insure in respect of the claim that we're concerned with. It's as simple as that, isn't it, as far as the language of the clause is concerned.
On the
Everything we've got elsewhere in section 2 is not concerned with a claim of this nature.
That's right, my lord, as far as it goes.
Right.
But the only reason I'm hesitating is that I'm slightly nervous that your lordship's trying to suggest that that's therefore divorced from the other provisions in insuring in
Yeah,
section 2.
that's the point that we're making. I mean, if you go, true it is, you've got infectious diseases on page 84, and you're absolutely right. The words in bold don't exclude proviso 2, and your point is that proviso 2 contains an aggregate limit,
Yes.
which we understand. And if you go, for example, to page 126, this is the extension for infectious disease, including the Food Safety Act.
Yes.
And that also said, under extension applicable to business interruption 2, which I take it to be a reference back to clause 2 or paragraph 2 on page 84, is extended to include, and then it has that. So that is, the food safety point is brought within 2. It extends 2 to food safety. But the point that my lord's making, and the point I was going to use, page 140,
Yes.
does not say this is an extension of section 2, infectious diseases, let alone say proviso 1 shall not apply, but proviso 2 still applies.
No, my lord, if one goes back to just the basic schema as will be seen by the reasonable policyholder, which I showed you a moment ago at page 67, that policyholder would know that section 2 is that part of this policy which provides cover in respect of the group's business interruption losses. And that is subject to the terms and conditions in that section. If one then goes to page 140, the opening words state in clear terms, under business interruption loss following interference, there's only BI cover provided by section 2.
I think you may be misunderstanding, but I don't have any difficulty with the suggestion that what we've got on page 140 is cover, which is a business interruption extension. That much is apparent from 56 and 57.
Yes.
Which has that. But what I am anxious to understand your argument on is which is the particular wording that matters for this cover. And you've drawn our attention at 56 to the 89.9 limit of indemnity.
Yes.
And you've drawn our attention to the wording at 81, which is the insuring clause in relation to damage business interruption, and has the reference to the aggregate limits and so on. But then when we come to page 140, which is the place where we find the cover that we're concerned with, it doesn't refer to limit of indemnity, capitalised, defined term, nor is that the expression that's used to cover the 1 million in the schedule at page 56. It uses quite different words, which is the company should not be liable under this extension for more than the amount shown against this extension in the schedule. And all I'm seeking to establish with you is isn't that the wording that we've got to construe? What's meant by not liable under this extension for more than the amount shown against this extension in the schedule? Isn't that the critical wording?
Yes.
Because this is the insuring clause, and the insuring clause subject to the amount shown against the extension in the schedule. Because this is what we have to construe.
Yes.
The general, what I describe as the general BI cover at page 81, fairly, when it refers to aggregate limits of indemnity as stated in the schedule, if you go back to page 56, limit of indemnity GBP, that's a reference to, depending on whether you're looking at gross revenue including increased loss of working or just something else. It's the reference to the 89.9 million.
Yes.
That's the aggregate limit of indemnity.
Yes.
But the point that we're putting to you is that unlike the cover in respect of infectious diseases, there's no reference at page 140 to the limit of indemnity at all. It simply says, not be liable under the extension more than the amount shown against this extension in the schedule, which just says, in quite general terms, limit 1 million. Doesn't even say limit of indemnity.
No, but the judge below held what that means. That means limit of indemnity.
Well, wait a moment. Limit of indemnity is itself a defined term at page
Yes.
72.
Yes.
Which is not used in the clause we're concerned with.
Well,
Is it?
well, my lord, yes, in the sense that if one looks at page 140, provided the company shall not be liable under this extension for more than the amount shown against this extension in the schedule.
Yes.
So that one has to look at the terms in that schedule. It's also subject to the terms, conditions, limits and exceptions to this policy. So it's not a splendid isolation. It's within the framework of the section 2 cover. One goes then back to page 56,
Yes.
and where does one find the amount? Item 15 on page 57, 1 million. 1 million of what? One goes back to page 56. The limit is 1 million. Well, what does limit mean? It means limit per occurrence. See, Mr. Justice Jacobs.
Therefore, you say it means aggregate limit for all assureds.
that
It's that step I don't follow.
Well, it means that there's one limit, my lord, for the occurrence. And we're dealing with a composite basis with related companies. And if there's one, no, if one has usual BI, but the prevention of access, one may be dealing with a classic example of a burst strain in Newcastle and a gas leak in Manchester. And as it were, no relatedness between the two at all. And there's a modest extension, and both will get, will say, I've got a separate occurrence, and there's the limit applicable to that. Here, where one's dealing with what we say is one occurrence that affected everybody, there's
Wait a
therefore
moment,
one
sorry,
limit.
Sorry, wait a moment. If you do have two separate occurrences to two separate premises, each of which during the policy period causes £100,000, are you saying that the £100,000 is the limit for both of them? I thought that was your case.
So take it in stages. It's said against me that there's a limit of 1 million per occurrence, and that every policyholder, even though they have the same occurrence, each has a separate limit. My point is that, taking a Malone defence case at its highest, they've identified in their pleadings 2 occurrences. Therefore, at its highest, there are 2 limits, but that is the aggregate limit for all policyholders. If there were, and I deny that, if they were separate occurrences, there would be a separate limit. Yes. What I'm disputing is that there are 40 limits, because each policyholder says, well, I've got 2 limits each. That's where the dividing line is. So I accept there's a limit per occurrence, but it's the same occurrence. And if it's the same occurrence, there's one limit, where it's set against me on this composite issue.
But you say there's one limit even if there are separate occurrences. It's an aggregate limit for all assureds of 1 million. Don't you?
No, I ran that below and I lost, and that's not been appealed. So I'm bound by the conclusion below. The limit is per occurrence, and therefore I do accept that the composite policy provides 1 million per occurrence. But in the context of the composite policy, if it's the same occurrence relied upon by all, and it is, then there's one limit across the board. Yes. And to that extent, in the words of Mr. Justice Jacobs below, they share that limit. They don't have it duplicated 20 odd times.
Right.
just for your lordship's note, in the judgment below this, the limit and limit of indemnity points was issue number 11, as answered at page 119 of the core tab 1.
Thank you.
So that's why we say that is a per occurrence limit, and if it's the same occurrence, that is a limit across the board. That's the short point on construction. I mean, there are lots of points that one could make in terms of the court may think are impressionistic about what a reasonable policyholder would think looking at this sheet and even reading the terms, particularly the definition of a limit of indemnity and the further restrictions in insuring clause 2 as to whether they would think that there would be an exponentially increased number of limits available to each policyholder. In my submission, no. It's stated 1 million per occurrence, and that is it for the occurrence. And that gives harmony to what's set out at page 56, namely the limits one sees at the top on a composite cumulative basis are obviously across the board. The limits one sees below are similarly the limit across the board and therefore aggregate, albeit they may apply on a per occurrence, per event, per strain basis. But it's only one limit, as it were, for that problem, not multiple limits for which X hypothesi is the same problem, i.e. the same occurrence.
Have you finished with page 140? I've got one or two things I'd like to ask you about it, but I don't want to take it out of your terms.
I'll nervously say yes, my lord.
Right, well this is the insuring clause. Under business interruption loss following interference with the business carried out by the insured.
Yes.
At that stage, that means each insured, yes?
All and any.
Yes, but it's the business interruption carried out by the particular insured who's making the claim, let me put it that way, is that right?
Oh. Not necessarily. It depends on how the business is operated.
Well, let's assume for the sake of argument that there are 20 separate companies each operating their own hotel. They've each got a claim under this
Yes.
cover at page 140. So each of them is an insured for the purposes of its claim.
Well, to be clear, 140 is interference with the business. The business is defined at 52 as hoteliers. So there's interference with the hotelier business carried on by the insured.
By the particular insured who's making a claim, otherwise you'd have a title to sue.
Oh, yeah, I have to take that point, my lord, yes.
Yeah. So then when we get to the insured peril, within 1 mile of the premises,
Yes.
that means the premises which are relevant to the particular insured that's making the claim. You couldn't say, well, we've had an insured peril of a bomb near the hotel in Glasgow, and we're going to make a business interruption claim in relation to disruption to the business at Heathrow.
No.
So those are both what might call individual insured specific elements of the cover that is created here. It's got to be business interruption to the particular insured, and it's got to have been as a result of a danger or disturbance which is relevant to the premises of the particular insured. So far so good?
Yes.
Right. So that is defining what the company is to be liable for. So
Yes.
if we treat this as the relevant insuring clause, this clause is saying, we the insurers agree to indemnify for business interruption losses vis-à-vis a particular assured by reference to a peril at particular premises. So far so good?
Yes.
That is the liability that this clause is concerned with. We then get to the critical words, which are the proviso, which is what we've got to construe. Provided that the company shall not be liable under this extension. Now, why doesn't that mean shall not be liable to the particular insured in relation to the particular peril, which is the liability for which this extension provides?
Well, because that is right in response to a claim made by a policyholder singular, but may not be if a claim is made by two policyholders, albeit with their individual claim. Because to tweak the example given by your lordship, there may be great difference between Edinburgh and Heathrow. If one takes a problem with a hotel in North Manchester and one in South Manchester due to a water metered event, that could affect an entire region. So there's one problem, and both policyholders may claim in the same way there could be a prevention of access that covers a wide area. But now the fact that they're both making individual claims for what they say are their individual losses tells one nothing about what this policy is doing in terms of the aggregate limit on the company's exposure to that claim.
Well, I'm suggesting that it does, because the limit that's imposed under this clause is a limit which the amount of the limit is the amount shown against this extension, but the limit applies to the company's liability under this extension.
Yes,
That's what the limit applies to.
yes.
And if the liability under the extension is an individual liability to each assured by reference to a peril that assured's premises or within a mile of it, that is the liability to which the limit is to apply. That's the point. That's the point on the language of the clause.
This clause is expressly referring to the schedule. So if I'm asking, what is the limit of my liability? I go to the schedule,
Yes.
and I see the 1 million under the heading limit.
Yes. And if you ask my liability to whom, is it to all the assureds or to the claiming assured? Because this is limiting liability under this extension, and this extension is dealing individually with liability to each assured, then the argument against you is that's what the limit applies to.
But what your lordship is there doing is divorcing in this hermetically sealed page 140 all the elements of the insured peril and all the issues of the basis on which the loss is to be presented, and then having quite separate in the schedule just the quantum referable to the individual claim presented, namely 1 million. But that, with respect, is not how the reasonable policyholder would view this. Namely, I look at the extension at page 140. I ask myself, what is the liability of the company under this extension? I'm told to go to the schedule. I do that. I see under item 15, there is 1 million. 1 million of what? 1 million of limit. Do I know what limit means? I do, I've been told by the judge below. It means limit of liability. As a policyholder being reasonable, I'm going to look what that means. And I turn to limit of liability on page 72 of the policy, and I'm told that is on a per occurrence basis. So there's aggregation language there that is going to bring in certain losses and provides the limit. So limit of liability is not just a bald figure. There's also inherent in it a mechanism which may aggregate or limit the liability, and therefore the policyholder sees 1 million as a limit of indemnity and turns to this clause and understands that is a limit any one occurrence.
So the policyholder should read the words, the amount shown against this extension in the schedule, which is in a part of the schedule that just refers to limit, as meaning the same as the capital L limit of capital I indemnity as defined elsewhere in the policy.
Well, if one were to ask the policyholder, my lord, what is that 1 million? The answer should be, well, it says on the schedule, it's the limit. It tells me. It's under the heading limit. I know what it is. I mean, there is a danger that one's seeking to pass out here the difference between the schedule and page 140, that one is entering into an arena that is, as it were, a textual analysis that is not that which one would adopt.
Textual analysis may be important. We've got aggregation wording. We've got it specifically by reference to a defined term, capital L limit of capital I indemnity, which is used elsewhere in relation to other aspects of cover, but is not used here. But you say that's something no one would notice, and it means the same. We should read it as if it said capital L limit of capital I indemnity.
Well, I don't need to go so far, my lord, as to say it's capital I indemnity. It's enough that I can point to a capital L limit, because the judge below found that limit means limit of indemnity. That was issue number 11, and that was found in my favour. So limit does mean limit of indemnity, and therefore when I look, and that's not been appealed, and therefore when I look at what I'm told to
It's my fault. I think I probably will have to look at issue 11.
no, because Hollywood Bowl did try to appeal this point, and permission was refused. So limit does mean limit of indemnity.
Just forgive me. Can you just show me that in the judgment?
It's got the core at tab 1. And there's a rather long page.
The issue itself is defined. You did give me the reference, but I didn't.
Sorry, the discussion begins, my lord, at page 49, after the parties' arguments, which are set out in detail. At page 219, and there's a long discussion that goes on to page 55, and one sees the answer at page 250. Sorry, paragraph 250, 51. And one sees on page 54 at 245, my lord, that the judge below rejected the aggregate argument on the basis that it was per occurrence and only per occurrence. That's what limit means. So if one goes back, my lord, to the point raised with me at 140 and the schedule, one is not looking just at the schedule and asking, well, what is the figure referable to my claim, policyholder number 1? So that's a 1 million given in the schedule. That is the 1 million per occurrence, the limit of liability, because that's what the 1 million is. It is the limit. Because one's dealing with what is ex hypothesi a composite policy and therefore applicable to multiple parties, if there is one occurrence giving rise to losses to multiple policyholders, but it's the same one occurrence, that limit is one occurrence and therefore one limit for that occurrence.
back to 140, doesn't that mean that isn't this defining what the occurrence is for POA?
This will be.
I'm not sure, my lord, I'd agree that that necessarily defines the occurrence. Part of the insured peril, one needs a danger or disturbance within 1 mile which prevents or hinders. That's not necessarily the occurrence such that if there may have been an occurrence which caused the same or the same consequential hindrance within a different 1 mile radius to another policyholder, that would still be the same occurrence.
No, but that's not what the judge has decided, is it?
No, the judge hasn't
What the
decided
judge says,
anything about occurrence, my lord. That's
what the judge says in relation to issue 10, issues 9 and 10, on page 55, is the defendant is bound to, this is in the context of, I think, of Gatwick, isn't it?
yes,
It's Gatwick with the 6
separate policies.
bound to indemnify each claimant in respect of each of the claimant's premises, up to a maximum amount of 1 million within an indemnity period of 6 months,
Yes,
etc. So he's dealing there for any loss or series of losses arising from any one occurrence.
yes, but
He's not saying that there's a limit of 1 million for everybody.
no, my lord. But those are separate policies.
I know, I follow that, but when he says at 251, well, I've already addressed that issue at 9 and 10. He's not saying the effect of what I decided at 9 and 10 is that there's £1 million limit for absolutely all claims by all the starboard claimants under this policy.
Well, take those stages.
I mean, otherwise one asks the question, fairly obvious question, what are we doing? Because if you're right on this point, there isn't an argument on this issue, you've won. Because you say, well, the answer to the point as to how many limits there are is there's only one, because there's only one occurrence.
Well, no, because it's pleaded there are 2, my lord.
Well, never mind whether it's 1 or 2, but I mean, the fact is that this is, what's said against you is that each claimant has its own limit.
Yes.
So that's the argument, and that's the argument which you're having to address, which the judge has found against you.
Because the composite point, because the conclusion in Gatwick was entirely orthodox, namely following on the finding
No,
that
but
there was...
that's not the point I'm making. You're misunderstanding the point. The point I'm making is that the judge has not found, as I read his judgment, that the effect of limit of indemnity, limit meaning limit of indemnity, is there's only 1 claim or 2 claims.
No,
Sorry, 2 limits, I beg your pardon.
no, well, that issue was held over. He did hold it was a limit per occurrence, but there was no debate before him as to how many occurrences. That was held over.
I'm not sure that's...
That was expressly held over.
Mr. Grid will disagree with you about that.
Well, Mr. Graham.
Anyway, we'll have to hear,
I mean, there was agreement that we didn't stray into the detail. Now, rightly or wrongly, we didn't discuss how many occurrences or what constituted an occurrence. Similarly, we didn't stray into what constituted a loss for the purposes of the Bath Racecourse. This was dealt with in the abstract without reference to further argument on how particular claims might be aggregated or calculated.
I don't know whether I can assess, my lord. We did try and appeal the judge's decision that limit meant a limit of indemnity. Lord Justice Mells did not give us permission on that point, but the judge's decision is that in relation to Starboard, there is 1 limit per Hotel Company or per insure.
That's what I was
That
looking at,
was
the
his
answer to
decision.
issue 14,
Yeah, that is his decision.
281.
And that I think is why we are here today, because Mr. Scory wants to say that however many companies there are, or call them composite insurers there are, they have to share, whether it's one limit or two limit, or three limits, or
limit or
whatever
two
they
limit.
are, it doesn't matter,
Yeah.
because that has not been determined. They have to share let's assume there is only one occurrence. They have to share that one limit of £1 million. And the judge's decision as it stands today is that that limit applies individually to each insured. And that's the decision we are seeking to uphold. I don't know whether that's, I'm sorry I stood up, but I thought I would seek to
Well,
clarify.
yes, and because if you look at what the judge says in answer to issue 14, page 281, the starboard indemnity is similarly capped. It's capped to 1 million, any one occurrence. But in respect of each separate insured, rather than by way of an overall cap on the claims of all insured collectively,
Exactly.
which is what I understood the judge should have decided.
And he did
That
decide.
each insured had its own limit of up to £1 million.
Yes.
Yeah, but as noted in 280, this issue related to 13, that was the composite point.
Yes, I understand how we've got here, because you correctly picked me up on my reference to the amount shown in the schedule at page 140 not being the same as limit of insurance as defined, and taking me to, it's actually issue 10 for Gatwick, but where it's
Yes,
explained,
yes.
but
There was some overlap in the issues.
issue 11, because the wording's the same for
Yes.
for Starboard. I understand that, and that if one follows that through, then what we're concerned with, for the purposes of the insuring clause at 140, is the limit of indemnity as defined at page 72. Is this right?
Yes.
Which is it means, for the purposes of sections 1 to 6, the total liability of the company for all amounts payable in accordance with the insuring clause under these sections, which to my mind begs the question of, does it mean the liability to each assured or the liability to all assureds? We don't get any aggregate wording there. That where we get the aggregate wording is at page 81 in relation to the physical damage insuring
Yes.
clause. That isn't carried over into page 140, is it?
Well, no, but I've made my point that one has the basic requirement there for BI in the aggregate. One has extensions under it, which for those stated in the pro forma language, i.e. infectious disease, expressly retain that limiting element. And then one has further extensions, beyond infectious disease by endorsement. And I readily accept that they don't carefully pick up the rubric, but it's my case that they may not, as it were, mimic precisely the language, but the function and operation within the policy operates in the same way and will be understood as much to the reasonable policyholder. Namely, does this extension at page 140 operate as per the other extensions?
Thank you.
Now, before the short adjournment, because on the timetable I've only got till 2:30, could I deal with Bath Racecourse? Because we're focused to date on the Starboard language.
Yeah.
This begins at the BR bundle tab 7. And again, I was looking at this as a reasonable policyholder to see whether there's any expectations as to multiple limits. The basic material damage cover by section 1 is found at page 90.
Yeah.
And then over the page 91, one sees the settlement terms. And there are 2 paragraphs there. The first is the value of the property, reinstatement or replacement. There's no reference there to any schedule or other limit. But then there's a second paragraph, which is that there is a limit for such property damage, namely the sum insured, and I'll come on to what that's found.
So I'm so sorry, I've lost you. Where are you at the moment?
91 final paragraph, my lord. And the settlement terms, 2 paragraphs at the bottom.
Thank you.
One sees in the final paragraph shall not exceed the total sum insured. That's not a defined term, but one sees the total sum insured in the schedule, which is at page 55, where there is a column for sum insured and then in brackets declared values. And obviously the figures stated at page 55 are in the aggregate. It doesn't say so in terms, neither there nor at page 91, but it's obvious from their face given the value that they were in the aggregate. If we go back to look at the basis of section 2, cover for business interruption, that's found at page 104. And one sees at the top of the page that the basic or paradigm cover, presuming damage to the premises, is set out in the first paragraph. And the businesses in the schedule, I'll come on to that. The maximum indemnity period is stated in the specification. One goes to that specification, my lord, that's at page 57, business interruption section 2, and one sees the sums insured again. And there is a triumvirate of sum insured, estimates, limits in the right hand column. And what one sees below my submission is clear to the reasonable reader are all in the aggregate or on a cumulative basis. The basic extension that we are dealing with is found at page 110 under the particular settlement terms and denial of access in the middle of the page. This section extends to include any claim resulting from interruption or interference with the business, and that's defined at page 76. Carried on by the insured, defined at paragraph 55 to include everybody, at the premises, which is not defined anywhere, in consequence of B, action by the police authority, etc. And then provided that application of other terms, etc., 1 million, any one loss. Now that was replaced with what is found at page 64.
It's condition 22.
Lord, yes. Yeah. And Mr. Walsh will deal with the meaning of public construction of that. For present purposes, and consistent with the cover I've just shown you in the schedules, which are rather simpler than in Starboard, the limit of 2.5 million, ex hypothesi, without straying onto Mr. Walsh's territory, any one loss, is a limit that applies to all policyholders in respect of that same loss, whatever that means, and that's not for today's debate.
There's no appeal against anything the judge has decided on this point, is there?
Yes, my lord. Mr. Walsh is dealing with.
No, I know there's an appeal in relation to any one loss.
Yes.
But there's not the same argument that you've been running in relation to Starboard doesn't arise in relation to Bath Racecourses, does it?
It does, in the sense that.
Well, hang on a moment. Is there an appeal from the decision of the judge by the insurers in relation to his decision on Bath Racecourses in relation to the same point as Starboard?
Yes.
Where's that?
That is at call bundle tab 10, the appellant's notice. Forgive me, page tab 10, page 282. It's the same issue. And your lordship will be forgiven for thinking that this, as it were, falls in the slipstream behind the starboard point, because if one looks at how this was addressed below, along with the other issues, one sees issues 22 and 23, call bundle tab 1, starting at page 69, a long discussion about the issues Mr. Walsh will deal with, and the composite point is dealt with in one paragraph, paragraph 374 on page 78. And in many respects, all I am asking the court for in upholding my appeal on this point is not to determine what any one loss means, but just give me the opportunity, come the hearing in May of this year, to be able to argue that any one loss is properly construed under the Bath Racecourse policy and means a loss at, as it were, the composite macro level, such that there is one limit. And that will be all a matter for the trial judge. But at the minute, I'm precluded from doing that by dint of paragraph 374.
So if we can come back to page 110, which is what we've got to construe.
Sorry. Yes.
For this policy.
Yes.
We don't find the limit anywhere else. We find the limit in the proviso.
Yes.
Leave aside the amendment for the moment. So the limit applies to the liability of the insurer. Paragraph 1 of the proviso.
Yes.
Liability of the insurer shall not exceed.
Yes.
And the liability of the insurer in the coverage is again liability to a particular insured in relation to a peril under A anyway, 5-mile radius of the particular premises of that insured.
Yes.
So again, why is not the inference that the qualification or the limit on liability in the proviso is a limit to the liability which is being imposed under this clause, namely a liability to an individual assured in relation to business at that assured's individual premises or within 5 miles.
Because it is any one loss. Now your lordship's making clear, well, that's pointing towards loss by a policyholder. And my retort to that is, I want to argue that that loss on a composite policy with a closely related group companies can mean loss not at the micro level, but the macro level, in which case there is a limit stated, any one loss. This assumes I'm wrong on the point Mr. Walsh is going to run.
Well, if you're wrong,
Anyone lost to whom? Sorry.
yeah, and it's
Anyone
exactly-
lost? Anyone lost to whom? The starting point is, does this limit apply per assured or to the policy as a whole?
Yes.
If it's per assured, anyone lost can perfectly sensibly mean anyone lost to that assured.
The problem, my lord, is that you're immediately, by doing that, straying into what is meant by any one loss. And rightly or wrongly, the parties have danced around that issue and not touched upon it. So there's not been any debate below, and nor in submissions in writing to this court as to what that means, because that is all for May, 4 days in May to debate that.
Forgive me, I'm not understanding it. The judge has decided that these limits are per assured, not per all assureds.
Purely on the,
each
not by
claimant is
reference.
entitled to claim up to the limit of 2.5 million, any one loss.
That's what's
That's
been
what he's
decided.
decided.
Now, you say he's wrong about that,
Yes.
because notwithstanding that this is a section dealing with cover per individual assureds,
Yes.
the use of the expression any one loss
Yes.
must mean that it's a per policy limit, not a per assured limit. Now, I'm afraid I don't understand the logic of that. Surely the first question is it a per assured or per policy limit? And if the answer is prima facie it's a per assured limit, then why can't it mean any one loss per assured? I don't see why the latter should drive the former.
Because if one looks at paragraph 374 of the judgment below, this was decided on the basis of the composite policy issue, namely the expectation point. Because it's composite, it replicates over.
Yes. Well, it's a construction point as well as a composite point.
Well, yes, but
We would say only a construction point.
yes. I mean, that is the issue on the composite point. I mean, to the extent that one looks to what the reasonable policyholder would understand.
But what the judge has decided at 374 is that each claimant is entitled to claim up to 2.5 million, any one loss.
Yes.
As he says at 373, I'm not deciding for the present how many losses there were. So on that hypothesis, if you read the two paragraphs together, he's not deciding whether any particular claimant has suffered more than one loss.
I know, but I mean, just to put that in context, there were amendments in November in light of what the judge said there. So the pleadings currently stand in respect of Bath Racecourse is that 566 meetings were missed horse racing and 699 greyhound races that are given rise to 1,265 losses, in addition to which there were 130 losses by reference to closures of pubs, golf clubs and hotels. Now that gives rise to over 1,400 losses that are being raised against me in May, with potential limits of 3.4 billion. So, but that's being raised because each policyholder says, oh no, we can now.
Yeah, but that's going to turn us on Mr. Gruder satisfying that whichever judge deals with it in May.
Mr. Kramer, I'm going to put my
Oh, is it? Sorry, Mr. Kramer, I beg your pardon. Mr. Kramer satisfying the judge that there is more than one loss per claimant,
Yes.
as opposed to it being one loss
Yes.
per claimant, which the judge hasn't decided. But I mean, well, that may be the consequence of the judge's decision, but that only explains why you're here. It doesn't explain whether you're right or wrong. Okay, is that a convenient moment to break?
Oh, yes.
2 o'clock, please.
All rise for fable.